All right, so I'm Greg Lambert. I'm from the New Jersey Superior Court, the Burlington Vicinage. That's a fancy word for county.
And I'm Shannon Dennis. I'm also from the Burlington Vicinage, and I run the criminal division.
Now, we were told these mics work pretty well. Now, if you happen to go to the Guns N' Roses concert last night, it's not us. It's not this that's buzzing. It's your own ears, Rick Pierce. All right? All right. All right. The program said we're going to be doing case studies from around the nation. That's not exactly the way. We're really going to be talking about New Jersey's effort in this area. We'll be touching on, what's going on nationally to the degree we know it, but we're not the experts in bail reform. We're two people who are living through bail reform. And we can certainly explain, what's been going on in New Jersey as far as implementation, but if anybody has anything to add from another jurisdiction, another state, what have you, please. We'd love to have questions. This mic will be going with you. This obviously is being taped, so if you do have questions, wait just a second so we can get you the mic. Anything else, Shannon, before we get going?
Nope.
All right, so looking for us. All right, we're going to be doing some background on bail reform around the country. We're going to have to give you some idea of kind of how New Jersey's structured. That'll help you get an idea of what we've been doing, the way we've been implementing things. We're going through, like I said, there's going to be a case study of implementing this, so we're going to be looking at the major elements in implementing this kind of a change in a statewide system. And lastly, we're going to be talking about communication, because that's been key, getting all of our judges, our staff up to date on what's going on, and then, of course, our system partners.
I think we want to add that we know that there have been several courses this week where you've heard some information about bail reform, or things that are occurring in other areas. So some of the information we have, at least initially, will be a little repetitive, so we'll probably move through it a little quicker. If you want us to slow down, just let us know. So at the mid-year NACM conference this past year, Tim Murray did a presentation about pretrial reform and changes that are occurring on a perspective, the reasons why. The video is on the website, on the NACM website, and it's actually a very good presentation. So he kind of does a very good summary of giving you all the information about the whys and why we should do this, and the reasons for the changes that are occurring. So you might want to just check that out if you have a chance. But to point out a few of his points, the view by many is arrest means guilt, that because you're arrested, you're at least guilty of something. Which is not true. We all know that. We all work in the court system. We know that that's not true. But that's the perception, that even if you're not guilty of everything, that you're guilty of something. Also, bail sends a message, tells people that we're doing our job. We're protecting the community. We're keeping people in custody. When in fact, it actually is just holding people pre-trial, that most of those people, and as we'll find out later on, just can't afford to get out. They're not high risk. They may not repeat again. They may have done something for one time, but given the crime they have and their economic status, that they just cannot get out of custody. Additionally, we find that we have so many people being kept in custody pre-trial that oftentimes they'll take the plea just to finish the case, just to get out, just to be released, just to go back to their families. And they've had so much time in custody pre-trial that our system is finding that we have cases where time-served sentences become the norm rather than the rare. And we find that risk-based decisions, that changing over to a risk-based decision or evidence-based decisions is not new. We have it in, I heard it earlier in a presentation that our insurance companies do this already to us. If you're a young driver, you're going to have a higher risk of maybe getting into an accident. We use it in other areas of our life all the time. When you want to take a loan out at a bank, are you a good candidate for that? There's parameters that they check to see if you are. Why wouldn't we do it here when we do it in other areas of our lives? So why bail reform? Why now? Why are we looking at it? Bail reform affects someone pre-trial in many ways. We find that people that have jobs. Some of them have very good jobs. They lose them. They lose custody of their children. We put burdens on family members to have to take care of maybe a child. If you're a single parent, you may have your children maybe get put into the child welfare system. You may have someone that's older or mentally challenged that you're caring for that now someone else has to take the role over of caring for them. In fact, some people have actually died in custody, and that article that's referenced up there is actually a very good article and speaks to that. It's someone that was in custody in New York pretrial on a very low-level offense that in fact passed away while in custody. And then again, we already talked about the plea, the pressure to plea to get out, that feeling of, even if you didn't do it, you want to go to trial, or you want your day in court. I mean, they deserve their day in court, but they just don't want to stay in custody anymore, so they just take the plea to move on. Bail reform hits the core of our values. All of us work for court systems. Fairness is what we look at. Even if the outcome that you have in your case is not what you were looking for or not what you wanted, we want people to feel that they were treated fairly. And in a system where our low-risk defendants are placed into custody on very high bails or bails that they can't meet because of their socioeconomic status is not a fair system. It's just not. Additionally, fiscally, and you can see the numbers up there, I don't need to repeat them for everybody, but we spend a lot of money nationwide on people to sit in custody pre-trial. And then some of them end up just taking pleas to get out, or some go to trial or whatever, but we find that they spend a long time in custody before their cases come to court, and we'll talk a little bit more about that. And we've also seen that it's also working in other areas of the country already, and DC is one of the areas, just an example that we've utilized, that 80% of the defendants released with, we found that 80% of defendants released without bail, that 80% of them make their court appearances, and 80% of them are not being rearrested prior to the disposition of the case. That's a pretty high number, and when you see later on when Greg talks about some of the numbers that what we had to look at for New Jersey, that these were the things that we were finding, and sometimes that's a difficult change for people to look at, and we'll talk a little more about that, but just seeing the numbers sometimes is staggering.
All right, so we have, again, heard a lot this week about what's going on around the country with all the shootings we've seen and recent events that we're not very happy to see. But it's speaking to a lot of distrust of the public in the system. And clearly, bail reform, getting people out who are not guilty, at least not guilty yet in the eyes of the law, is a key thing. People are in favor of risk-based assessment for release. You see up there 70%. Obviously, a whole bunch of national organizations, COSCA, NACOM, and others are in favor of this. We believe now the public safety assessment, that's the risk-based instrument that we're using. It's used in 20 jurisdictions around the country. We believe New Jersey will be the third state to utilize it statewide, so there's some momentum there as well. The Chinese curse is, may you live in interesting times. Maybe that's not such a bad thing. When you look at the society, the 70s could certainly be looked at as a rather liberal time. The 80s and 90s, we had the war on drugs. I know everybody here is probably well aware of what that did to our system. Crowded dockets, crowded jails, what have you. And now it seems like we might be swinging back to more liberal times, although it doesn't feel that way. We've got, gay rights, or, marriage rights are up there. There's legalization of marijuana, or at least decriminalization of marijuana, and now there's this push right now for, bail reform, for some kind of criminal justice reform. And I think that's kind of, it's a good thing. Again, for us as professionals in this, in the courts, this is what we look for. We want to provide fair outcomes. We want people to feel that they're getting a fair shake, and this is the way to go about it, I believe. I was shocked, actually, when we were looking at some of the information from around to find out that it's just the U.S. and the Philippines that allow commercial bail bonds. I would have thought there'd be a few more places, but we really seem to be an outlier on this at the moment. Guys, John. Got it. All right. So we don't want to go through this part too much. Like we said, we've been talking about this all week, if you've been going to sessions on this. You got a question, sir? 1 second.
Question is when you're saying that only 12% reoffend when they're released on pretrial, are they supervised or non-supervised, or is it a mixture? I think that's one of the reasons that we're kind of hesitant to move that way, because we feel like, well, we got to put these people under supervision, and we don't have that workforce to
Wait, go ahead.
monitor them.
That sounds like it's on. Okay. We're going to be using pretrial services monitoring. A lot of jurisdictions do. Now, this is where we bump up against our knowledge. We went out to see it in Kentucky. They have pretrial services, have had it there for a long time. I personally, I'm a chief probation officer, so for me, yeah, I'd rather people be supervised than not. We will be going into just kind of the metrics on how we're going to decide whether someone gets monitored and what the conditions will be that they get monitored under. So we believe it should be done that way. I imagine most folks do, but
So will your tool be able to help you with kind of determining what if this person needs supervision or not?
Yes, our tool, and we'll show you a little bit about the decision-making framework. We'll show you in a little bit, but our tool is going to give us guidance on what level the person should be monitored at. Should they have higher conditions? Should they have minimum conditions? And we have found through the research and from our experiences of visiting other jurisdictions that the more conditions you put on someone, the more difficult it is for them to succeed, because we're making them do more and more, and we're finding that the less amount of conditions that you have, the more likely they are to return to court, the more likely they're to be successful prior to the case coming to disposition. But we will have monitoring in New Jersey, and some of the other jurisdictions, like Red said, we did visit. They have some level of monitoring. But I'm not sure. It's different. It varies for everybody. We're still developing that, and we're working on that.
yeah, if you're familiar with the federal system, the federal pretrial services is very intensive. They have more services, frankly, than we do for regular supervision probation. But part of the reason we were told that that's the way it is just it takes so long for those cases to finally get disposed that I guess, it's 1, 2, 3 years, whatever. They want to make sure somebody's taking, watching these folks. But Shannon's right. The research is clear that if it's a low-risk person and they're getting over-supervised, they tend to be, more likely to fail to appear, more likely to reoffend. Anything else you got? Or okay. Anybody else right now before we move on? Now, we like that. That takes up time. We'll be done sooner for this. All right, so I wanted to say we wanted to talk a little bit, to give you a little primer on New Jersey, on how our court system is organized. We're a unified court system. We've been unified, I think, since maybe like '97. We have 21 counties. They're organized into 15 districts. As I said, we use the fancy word vistinages. I don't know where they got it, but we love it now. So, so that's to our advantage. The other thing about our court system for statewide is that we've had unified court IT systems in place since roughly the mid-'80s, which also has been a big plus on trying to get this off the ground. Now, kind of on the other end of the ledger is we have an awful lot of municipalities for the size of our state. Several hundred, 500 up there, but over 500. And that roughly equates to about the same number of police departments, although in some of the smaller municipalities, the state police handle policing activities. But that makes it tougher because you've got hundreds of folks, hundreds of court administrators, hundreds of court municipal judges that need to be brought up to speed. And just like anywhere else, municipal courts, they have some of their own ways. They are essentially managed out of the AOC. And as you can see, at the county level, we've got the assignment judge, is our head judge, matched up with our trial court administrator. Then under that, you've got 8 divisions, but the ones that we're kind of highlighting right now are the practice divisions: criminal, family, civil, probation. And we do have, at that level, a municipal manager who's in charge, an administrator who's in charge of all the municipal courts, along with a municipal presiding judge. I think that's about it on that. Any real question? That's good. Is that fast enough for that? I know everybody does this stuff, so.
Does each one have their own pretrial division, or
what's going to happen is each county will have its own pretrial services unit, and it's going to be part of the criminal division.
Even the smaller ones?
Well, there's
I'll go back.
each of the vicinages, all 15, each one will have a pretrial service. So some, where it's a multi-county vicinage, it'll be a little bit more challenging. But we've been dealing with that kind of, one manager, 2 or 3 counties for a long time. All right. All right, so we believe these are the elements we think are necessary to effect a change in the system. It's probably stuff everybody here is well accustomed with. A vision, an evidence-based approach, scientific processes. You got to retool procedures, quality control. You can read it. Anyway, go to the first one. All right, so you've got this new thing. You want to implement. You got to get people revved up. You got to get them to believe that this is something that they want to put some effort into, learn about. Now we all have jobs. We got to do what we're told, but it's going to be a much better job we're going to do. I believe personally, if you get people excited, motivated, focused. You want to make sure that they get that this is, a large movement that they want to get behind. That it speaks to our values. Go to the next one. Actually, go up one more. Go back up if you want. Those 3 principles: innocent until proven guilty, right to a speedy trial, and movement to a philosophy. You can't read it because it went a little low, but least restrictive mode of monitoring. These are things that the Chief Justice, Chief Stuart Radner, and our acting administrative director, Judge Glenn Grant, have been stressing that this is why we're doing this, to make sure that we live up to those principles.
Sorry.
2 people with 1 control, it's a bad thing. So here's just a basic outline of kind of how we got to where we are. In 2013, there was a jail population analysis by Dr. Van Osteren. She's connected at the time with Luminosity. We're going to go into what that report found in detail in just a second. But that kind of started the ball rolling. After that, the Chief Justice and the Administrative Director pulled together a multifaceted committee. It was people from the executive branch, legislative branch, governor's office, attorney general's office, public defender, and they went through and they came up with something like 30 recommendations. I've highlighted a couple up here. One is obviously we want to release people based on risk. We're going to be monitoring them with a pretrial services unit. Bail is going to be largely eliminated. There is going to be some. We'll talk about that in just a bit. And they also recommended that the state constitution be altered to allow preventive detention, because up to now it was always a right to bail state. And even if you had committed murder, you'd still have that right. But at any rate, that's what's changed. There are now also new speedy trial rules. That's why our administrative director is couching this not just as bail reform, but more as criminal justice reform. If you don't get released, then these new time standards are going to kick in. Again, we'll talk about that in just a bit. A new law came out in August of 2014, and the Constitution was changed, I think 2015, was it last year?
There was a vote, went to vote, so our state people came out and voted that they wanted this change.
And there's the vision. We want to make sure that we're doing what we're supposed to do, fairness and justice, and make sure that the public understands that this is what we're about. So that's the vision that was created. It's been championed by our administrative director and our chief justice, and kind of a no-brainer for what we do, I imagine. It's just a good thing. I don't know. Are there any questions at this point?
This is the trouble group, I see it. I'm just saying, I'm
I
kidding.
just have a general question. You might be getting ready to address this, but how did the bail bond companies react in New Jersey for all of this?
Oh.
They love this.
Yeah. They were clapping and they were excited. Actually, they are still giving us issues. They're still trying to take this back to the court and back to be put back on the ballot. They're obviously not happy. They fought very hard for this not to pass in New Jersey.
But again, speaking to the times that we're living in right now, I think the public is going to be able to overwhelm them in a political sense with their desire to have this sort of change made. Thank you very much for that question. Anybody else?
What kind of outreach did you do to the public to have passed on your ballot? Because I agree with all of this, but I think sometimes it's a hard sell to the public.
I-
In general, to say, like, they don't always understand.
I actually,
Guilty,
right.
right? Their first thought is, how could this person being let out of jail when they committed this crime? So I'm
Right.
surprised it passed on the ballot.
Um,
What kind of public
Actually, that's a really good question because we aren't involved in that piece of the process, but it was a fairly, I wouldn't say it was overwhelming, the vote to approve it, but it was pretty significant. I think we were at a time when it came onto the ballot that people had been talking about this. It was very big in the media about all these changes, and I think that's where people said, yes, we agree this needs to change. Now, to be fair, all of these other changes about speedy trial and all that, it wasn't spelled out on the ballot. It was basically just the reform piece about making sure that we held people. And I think the big draw, and this is my opinion only, is that the detention, the pretrial detention piece, I think, was a big draw for lay people who don't understand the system. They're hearing that your most serious and your highest risk offenders can be kept preventative in detention without bail. And I think when people heard that, that's what probably triggered with them the most to say this is a good thing, because we don't have that now. I mean, like Greg said, you commit murder or you commit the most heinous sexual offense in New Jersey, we have to give you some kind of bail.
And I'll also remind you, a couple of slides back, that there was a poll there, and the public, 70% of the public felt that they would rather people be released on risk as opposed to, as people pointed out, just a placard with you did this, you pay this. I don't remember, because we lived there, but I don't remember commercials or anything. The judiciary obviously doesn't do that, usually that sort of campaigning,
do
if you
that,
will.
yeah.
But it didn't, I don't remember a big public campaign. It really just seemed like one of those times where it gets on the ballot, people read it and like, okay, makes sense to me. And again, I go back to that if 70% of the population believes that risk-based assessment is better than the way we've been doing it, it's one of those easy, I agree, it'd be nice, it's nice that we didn't have to do that, but.
Yes.
Got a question.
And then-
Who were the stakeholders that came together to get your tool created for the assessment?
All right, we're gonna,
Get
you're a
that.
little ahead of us, so.
Sorry.
And this gentleman on that troublesome row right there had a question.
They're not trouble.
Well, there's two of
I
them
love
then.
their questions.
So just to clarify, what was on the ballot? Was that the constitutional amendment?
Correct.
Okay, because I'm from Wisconsin, we're also implementing the PSA tool in my county, but we do have that pesky right to bail in the Constitution.
Right.
So we're still going to have to kind of struggle with that. Thanks.
Right behind you.
Yes, we're from New Mexico, and we're the ones that have it on on the ballot coming up in November. And as judges, we can't buy advertising to support it.
Right.
The bail bondsmen do intend to fight it. And of course, they're going to have a lot more money than we have. Our Chief Justice basically is going around to different cities and talking to the variety of different groups, Rotary, Kiwanis, and those things, telling them what it's all about and publishing articles in the newspaper. And that's about all we can do as a judiciary.
Right. And I would agree, we have the same issues, but in our governor and our Chief Justice were on the same page about this reform. And so our governor, when he would speak, would talk about it, and it would be in the media, and that's, I think, where a lot of people started hearing about it, and there would be articles. We did have the bondsmen, though, that would also write their editorials and things to combat it, but I guess their voice was not as strong with the people as the rest of it.
And I'll also harken back to we're the people living through the reform, not the ones necessarily that are driving all this. So this is a really good question, and if you want more information on this, we can get you hooked up with the right folks.
Yeah.
Okay.
Especially for those states that are going through it, we can try to get back to them about it.
All right. So we now have a vision. So the next step here is we're going to be looking at the evidence. That's following an evidence-based approach. This is a fairly popular thing at the moment. I think more and more we see that we're trying to let the numbers drive us. Tim Murray, again, the presentation, we're we're highly suggesting you take a look at if you get a chance. Talks about the fact that now, because IT has gotten to the point in the court system that it's getting powerful enough that it can, help. It's a lot more powerful. We have a lot more information available, and we can utilize it a little bit better. So now we're in a position to let the numbers drive what we do a little bit more. And obviously, if you know what you're aiming at, you're probably going to hit it a little bit more often. All right. So we're going to need data to define our problem. We're going to need data to test the validity of our solutions. And we also want to make sure, you want to do this sort of thing because you're only going to get to do this once. If you start and you fail, we're talking about the public and whether or not they want to, support this, and bail bonds companies, whether or not they want to fight this. Well, you better make sure you're doing the best you can with the first time, because the second time might not come. Okay, so I said I was going to get more into the details of that 2013 study. So any given day, we've got 15,000 people incarcerated in New Jersey. It costs about $80 a day per person, so an awful lot of money. Finding that nearly 3/4 of those folks that are in jail in New Jersey are there pre-trial. They have not been convicted of anything. That's amazing. 3 out of every 4 people in jail. And they would the vast majority would be released under this scheme. We also found one that really strikes us, is that 12% of those folks were there for a bail of $2,500 or less. Now, most of the folks in this room, I assume we all work for the courts. We're sort of middle class because, the courts. But at any rate, that's a decent amount of money to us, but we could probably find it. We could find it on a credit card, maybe a friend, what have you. But obviously for a lot of folks who don't live that sort of life, that are more living day to day, that's a ton of money. And it's enough to make them stay there for months at a time before anybody's actually found any proof that they've done what they've done. The other thing here, because I said this is not just reforming their bail process, it's also implementing new speedy trial requirements. Now, those numbers are a little small, but when this was done, our backlog for criminal municipal cases was 41%, and you could say 53% in pre-indictment and 45% post-indictment. So a lot of backlog. Now, we had pretty aggressive time goals, and the new goals are actually maybe a little bit more kind to us, but still a significant amount of backlog. I don't know if you guys have the same way. It's numbers you're not particularly proud of it, but it is what it is, and this will be an effort to try and help that out as well. So putting this together, you look for things to jazz up the slides, find this or that picture. Your colleagues have certain things that they're good at and certain things they're not. I happen to like numbers. Shannon, maybe not so much. I show her this thing. Look, I got the normal distribution. She's like, yeah, that's great. So here we are. All right, so as we said, we're focusing on risk of failure to appear, risk of reoffense, and the risk of violence. We need the law up there. That's the law that we're talking about. The NJSA law there is requiring us to have a objective, standardized risk assessment instrument. We've worked with the Arno Foundation's risk assessment instrument. I've heard earlier there's a lot of other instruments out there. This is the one we decided to go with. That one came evidently from quite a few cases, 1.5 million cases across 300 different jurisdictions. Dr. Van Nostrand then took that instrument and retrospectively ran the numbers for folks who had been released on bail years previous. And what she ended up finding was that it was race and gender neutral, which is key given what we're trying to do. And what it's going to give us is 3 things, 2 factors. One is the rearrest. One is a chance for failure to appear. And then we're going to get an indicator, it's like a yes/no on whether or not there's a chance for violence. Now, we talked about how it's going to guide our decisions as far as pretrial release and what we're going to do as far as monitoring. We're determining that the decision-making framework. I think, hopefully, I can find. So the numbers are here a little small, but at the top you've got, let's see, on the bottom you've got failure to appear 1 through 6. You're gonna get a number 1 through 6 when you run the numbers. At the top it's new criminal activity, again 1 through 6. And like I said, there's also gonna be a flag for violence or not. So you're gonna run this, get a 3 and a 2, and you're gonna come out with the suggested conditions.
And the numbers, I'm sorry, the numbers here are showing, the numbers on here are showing where the percentage of our population, where the individuals that are incarcerated, where they think that they'll fall based on the studies that were done on our cases.
So now all the hands go up. That's
Yeah.
all right. That's what we want.
Go ahead.
Were there certain violations that were taken into account, like DV, for example? Did they get extra points, or were they just not even eligible for this?
Well, what does happen? You've got 9 risk factors that are being used. One of the good things about it is that we actually don't need to conduct an in-person interview to run this. And I can go through this. I'll zip through the factors. It's age at current arrest, current violent offense, pending charge at the time of the offense, prior DP conviction, disorderly persons, prior indictable conviction, prior violent conviction, prior fail to appear in the past 2 years, and prior fail to appear older than 2 years, and prior sentence to incarceration. Actually, juvenile numbers right now are not included,
DV.
but you said DV.
Yes.
DV, the family case management system is one of the things that is looked into to come up with the score.
Yeah.
Yeah.
It's considered, it will be considered part of, when the tool is run, it'll pull from that system that handles our domestic violence cases, and that'll be part of the process of determining what level they would fall
So
at.
you treated domestic violence the same as any other crime as far as the risk assessment?
I don't know.
I think it would count for failure to appear in court, but it would have to be a violation, I believe, of a domestic violence restraining order. I'm going to harken back again that we're the folks living this. But I'm saying that because if you really, I mean, this is the meat and potatoes of this, and there's obviously a lot more that could be going into if you're interested.
But
We're
that
going to
is
have
a
we're going to have something similar to this developed as well. It's not done yet, but it's going to be a response grid. Basically, it'll be response to failure to live up to conditions, and it will also come up with suggested reaction for pretrial services staff. A couple more questions.
Go ahead.
It's
He's the
civil in nature, so you can get a restraining order. The crime is when you violate the restraining order, right? And then, yeah,
Oh, okay.
what you can obviously have related criminal charges, and then it's a decision on the prosecutor's point when there is a violation whether to treat it as an indictable charge or not. So,
My question had to do with your violence flag. We have a risk assessment in Allegheny County, and we're in the process of using the Arnold Foundation assessment as well. But what is the violence flag? Like, what is the definition of violence? Is it aggravated assault? Is it somebody with a gun? I mean, is it, indecent assault of a child? Is that violent? Harassment? Like, what is your definition of violence? How did you come with the violence flag? I guess is the question I have.
good question. At this point, I'd be guessing. I would assume it's what we all, like you're saying, a probably an index offense. Murder, assault, rape, robbery, all those. And then after that, I honestly would need to talk to somebody else to get more details.
In the violence flag, it looks at the current offense, and then it'll look at your past offenses as well, and see at what level they were at. Did you have, perhaps if it was part of a domestic violence or a murder, aggravated assault, even your sexual assault cases or sexual offenses could be considered violent, and but they tier them a certain way to determine if the violence flag should be hit.
All right, so we now have gotten some, we have a vision. We've been looking at data to try and drive what we want to do. We've come up with some scientifically valid instruments, and really the next step is to have people like us start to figure out how this is going to work in our current system. Yes, sir.
Okay, so
on any given day.
When you were implementing the, I guess the screening, right? This is the Arnold tool. Did you go in and you have a team to go in and apply the screen or the assessment to the 15,000 that were in custody at the time?
What Dr. Van Nostrand did was the retrospective study. So she went back and pulled records of folks who had had bail. I'm not sure what the period, but let's say it's like a year. Yeah, I don't know what it is, but she looked at that data set and then figured out what would have happened had they gone through the risk assessment, what their conditions would have been, and figured out that it would work. That's that. We didn't do it. We didn't actually take new people in and do those use the instrument on new people. She used it
So
retrospectively.
now you do, and so now the tool's being used prospectively.
We're going to get into it. At the moment, we've got pilots, and they're running through the tool on new cases
And
while
just
they're
a-
still doing the current process, because we are not running effective until January.
And just one last thing, for her retrospective study, what was the size of that sample that she?
It
Yeah,
was,
you got it. It was.
It was over 13,000 cases or more that she looked at, maybe 20,000 cases somewhere. It was that high. It was a very high number. They took a very large sample so that they could validate the tool to what we have. Ma'am?
Has the PSA had any impact on that 15,000 plus?
Well, this law it's implemented, it becomes effective January 1st, 2017.
Right.
So, no, not yet, because it's not really implemented yet. But
Our pilots just began in March, so the first pilot is in full bloom, I guess you should say now. The second one just rolled out in July. The third one will roll out in
see,
August.
you all had good coffee today. That's why you're 3 or 4 slides ahead of us. I get that. I'd be asking the same thing. And all right, let's go.
I love
All right,
the
it's fine. It's fine.
In the afternoon, you're
I like the morning. I'm good.
There's one back there. There's one right there too. You don't have to walk so far.
When you read through all the risk factors, one thing I didn't hear was new offenses while you were already out on pretrial. Is that something that it takes account for? Because I know you mentioned convictions, but somebody may already be out on pretrial. Are they just gonna, if they commit the same exact offense again,
If
are they
someone,
gonna score the
I'm
same?
sorry, I don't mean to cut you off. No, those factors are the ones that she's using, that Dr. Van Nostrand is using, that the tool uses. But if someone is out and gets rearrested, the tool will be rerun. And
But there's not a
that new offense would then count as their latest offense.
Even
on
though
this.
it's not a conviction yet?
It's an
The only thing that you mentioned.
one of them is an arrest. One of the factors is arrest. So
Oh, it is? Okay.
arrest would have been in there.
They have to, every time, I want to say every time, but because we're just assuming that everybody's going to get rearrested. But every time someone's rearrested, if they're out on pretrial release, they have to go through the whole assessment again. Even if it's like 3 days from now, they still have to go through the whole process again because obviously there's been a change in their circumstances and their status.
All right. One or maybe 2 more, and then we got to keep rolling because, like I said, you're a couple of slides ahead of us, and I'd hate to be like, hey, like 5 slides. Go for it.
Wave this off if you're going to get to it, but I'm really interested to know the word nimbleness up there catches my eye. If you're going to talk about that, wave it off. And the second thing is, how will the program account for, or the model account for, the need for and the interest that judges may have in using their discretion to override and what have you? And if you're going to get to it, I'll stand by.
I can actually, I'll speak to it now. We might get into it a little later, but I'm glad you brought the question up because this is simply a tool that will be utilized for the court. It's not, it will give them the recommendations for conditions, the recommendation for the risk level. The judge will still have the opportunity to review everything. As Greg mentioned a little bit, the juvenile records are not part of the assessment process at this point, but we will supplement with that. And additionally, out-of-state records will have to be supplemented in a little bit into the tool, and I'll get into that in a little bit. But the judges will still have the authority to make that final decision. If they don't agree and they think the person should be on a lesser conditions or lesser level, they can certainly do that. The higher level piece is a little difficult for them. They have to put findings on the record. They have to be very specific why they would deviate from the risk level at that juncture. The one thing that I'm going to point out now, which will come up again later, but it's important to know that if the risk level comes back saying recommends preventative detention, that our judges cannot simply say the risk level says detention, we are going to hold you in detention. Our prosecutors have to make the motion for detention, and if they fail to make the motion for detention, the judge has to release that person at that juncture, with conditions, obviously, if they're that high of a level, but they don't have the authority to say this person has to be detained. They can say the recommendation is detention, but if the prosecutor's office doesn't make that motion, they can't do that. Now, we all live in reality. The prosecutor's offices are going to make those motions, but and then there has to be a hearing, which we'll talk about as well.
The use of the word nimbleness is my fault. It was debated. I put it up there, and here it is. Now, I'm going to be hearing about this for a while. Thank you very much. Just saying. We're going to keep rolling. We've got a lot more to go through here.
Okay, so next we get into the retooling of our procedures and personnel. Obviously, this is a very new program for us. We never had it before. I have to now, actually, I'm just going to move around because we're on the discussion, so I feel like it's more of a discussion, not so much this. But the decision was made. There was a lot of discussion about where this unit should be. Should it be a standalone unit? Should it be with the probation division where Greg works? Should it be with criminal? Should it be a hybrid where we share it? The decision initially the thought was hybrid. So we would share it, we would share the responsibilities, we would do the front end of it, they would do the monitoring piece of it. And then later on we found that probably wasn't the best way to go. So the whole unit is going to fall under the criminal division. So it will become my responsibility, and other criminal managers statewide will be our responsibility for the entire program. So we already have individuals that work in what we have now as traditional bail. And we're going to continue to have traditional bail. I mean, it doesn't go away. It's not going to be gone on January 1st when our system kicks, when this new law kicks in. Because if you're arrested on December 31st, 2016, guess what? You're under the old bail law. January 1st is not when it changes. So up until then, we're going to be dealing with monetary bail. So we were trying to decide, and on a statewide level, how we should utilize some of the individuals that are currently working in regular bail, because it's still going to be there. Should we move them over? How should we utilize them? So the decision was made because we're trying to make, this unit is separate and apart. It's not probation. It's not, these people aren't guilty of anything. It's simply to get them to come back to court and to appear and not reoffend while they're out. It is not, you're guilty, you need to have 100 conditions. And we wanted to treat them differently. We wanted to make sure that they were treated differently, and they should be. So we have a whole new set of individuals who will be working in that unit. There are different titles from what we're used to in probation. They'll have different roles, different duties. So it's the personnel that we have currently doing that will continue to do some of the bail work that we have, because we're going to have to run a parallel programs for quite some time. I'm going to have two tracks, the old way, the new way, and until that phases out. And gradually it will. We won't have as much monetary bail. But there is a little caveat. Our new law does allow still for certain areas of monetary bail to exist, and we'll talk a little bit more about that. But for the most part, it will eventually go away.
While we're talking about this thing, the one thing we didn't mention about the law, which was obviously very helpful, is it also included provision for some increased and some new court fees to fund this. Because obviously we're talking about new personnel, new units, and where you're going to find that money. So that was part of our law that obviously can't live without.
So the this decision has to be made within 48 hours, which is a change for us. Our Chief Justice, who's been a very large champion of this, would love it to happen in 24. Eventually, we'd like to get to that point, but initially the law calls for 48, so we're starting with that. But we understand the goal is to eventually lessen that down to 24 if we can. So now we're asking staff and attorneys, our stakeholders, which are our prosecutors, our public defenders, even our county partners, we deal with county level individuals, listen, our whole process is changing. We are no longer a Monday through Friday operation. We now become a 6 to 7 day operation. Includes weekends, we have holidays that we have to work now. We have to restructure this piece, and it's a big thought change. Additionally, we have to work on how's the weekend work going to look. It's probably going to look a little different in my jurisdiction as it will for a larger urban county or a smaller county. And I want to emphasize that even though how it looks, the weekend court will look, you should say, some people are opening their courthouses, some are doing it virtually. We are trying to do it all virtually. the process will be exactly the same in every area, which I think is important, and we'll talk about why when we get to challenges. We now have to have centralized first appearances or central judicial processing. Some call it, it's the same sort of thing. Initially before, at least in my vicinage, if you were picked up on what's considered an indictable offense, a Superior Court offense for us, and you posted bail right there at the municipality, or you were released on a summons, the municipal courts would have you back in for your first appearance. Well, this all changes. Everybody has to come now to the Superior Court for their first appearance. Doesn't matter if you are ROR'd, or if you were able to post bail, you have to report to the Superior Court for your first appearance. So that's another big change for us. It's a lot of additional people coming into our courthouses. It's a lot of additional court time. My staff had to come up with the new listings and schedulings. So that's a big change. And then we talked a little bit about preventive detention. We talked about, Greg talked about the overhaul of the speedy trial requirements and the court rules. And some of the speedy trial requirements that kick in are for our people that are detained. The idea is that we want these individuals who are detained to have their day in court as fast as possible. So if you're detained, prosecutors have 90 days to bring an indictment to you. If they fail to do so, you will be released with some kind of conditions. And then after the 90 days, they have 180 days to resolve that case. By plea, by trial, however it happens, they have 180 days. Again, if they fail to do that, then they'll be, you shall be released from custody with conditions, obviously, in some of those cases. But as with anything, there's excludable time in there. So the 90 days or the 180 days may end up being much longer, but that's because of events that may occur. Someone may apply for drug court, or someone may apply for the pretrial intervention program. Those are just some examples that may toll some of that time to allow for that process to occur. We talked a little bit about repurposing the personnel, the graduation, we talked gradual transition we talked about. And we're still, as Greg mentioned earlier, we're still in this process. It's still forming, we're still going through it. The monitoring piece is still being worked out. And I notice we say monitoring and not supervision, because we're trying to really change the thought process on who these individuals are. They are not convicted of anything. So we have changed some of our terminology to suit that purpose. So we are treating them as they are, as they're not convicted of anything. There will be, and as we're finding and we're going through the process, the law allows for a lot of conditions to be imposed. GPS monitoring, electronic monitoring, however you want to call it. There could be some field work, there could be drug testing, all kinds of conditions that can be placed. And even though the law calls for that, we are really trying to look at having the least amount of conditions. What will get that person to return to court? Because really, it's about getting the person to appear to court, letting them have their day in court, and moving the case through the system. It's not about imposing a million conditions on somebody that they may or may not be able to live up to, and then we have a process of bringing them back into court, and then we're bogging down our courts with all these violations. And we're still in the process of creating those policies. There is a separate committee, we'll talk about all the committees that we have, but there's a separate committee that is discussing how we should handle some of those things. And one of the key things is dual supervision. What if somebody's on probation already, and now they have a new case, they're coming through pretrial services and they're on monitoring? How do we handle those people? Should we handle them differently? Sorry you're tired, because we're exhausted. Greg and I have been part of this. We've been actually, I'm going to say lucky enough, and I know most people would say, oh God, another meeting, we have to go to this. This is actually a very big endeavor for New Jersey to take on, and we've been asked to be on some very high-level committees that a lot of this information that comes from the smaller committees gets vetted through. It's a very good opportunity, but it is exhausting. We've been in it now, as we said, about 2 years, and sometimes you need to just remind yourself what the vision is and where we're going to keep that momentum going. But when we start, as we're starting to see results, it's becoming, it's actually really kind of cool, which I know sounds kind of weird to say, but to be part of something so big and so changing for our state.
Our acting administrative director is fantastic at this and making sure that at every meeting pulls out something to make us remind us what we're doing, make someone stand up and explain why we're doing what we're doing, and it's good. It's something when you're doing this sort of thing, got to keep that kind of rolling.
Right. It's just, sometimes we just need a reminder that it's for the best. It's a positive thing that's happening. So now we need to talk about some quality control. We've talked about the vision, we've talked about the evidence-based approach, the identification, implementation of scientifically valid processes, Greg's favorite thing. We talked about the retooling of procedures and personnel. But now we need to reinforce this vision, and part of that is what Greg just mentioned with our director, our acting director says, you know, he'll make us just remind us a quick, and it's not like nobody sits up there for 20 minutes and talks about what criminal justice reform means to them, just quick snippets, and it's enough to get us like, yes, we need to be back, we're all back on the same page, we're all moving forward. We talked about how it's not probation, and for me, and I think it's probably more so for me because I am the manager that's going to be overseeing this new unit, is that I need consistency. I can't have my county or my vicinage doing something different from the vicinage next door. How we use our resources and our facilities and we work with our county partners may all be different, but the process, the procedures, they need to be the same, and that's what we're trying to accomplish, so that what I'm doing in Burlington County is the same as what's happening in very urban Essex County or Camden County, that the outcome is exactly the same through the process, not, and it's not different. So that's been a big push by the criminal managers statewide, even to the point of using the same terminology, because so here's our systems. Pretrial services, it pulls live scan. I'm not sure if everybody's familiar with live scan, but the old ink and roll fingerprinting has kind of gone by the wayside, and live scan is you put your hands on, it scans your fingerprints, puts it into a system. And I'm just going to point out, because we don't have a whole lot of time left, but this is a key piece for us. The technology piece in New Jersey is huge. We are relying very heavily on technology, and actually we were one of the first states to be relying that much on the technology, and it all starts with the live scan piece. It pulls from the live scan, your records come up. When you live scan, when the law enforcement officer live scans your fingerprints, all of their history from these systems that are here, which I know are a lot of acronyms for most of us, but there are systems that we use, jail system, our own system in criminal, family system, and NCIC, I think we're all familiar with. But it pulls all of that, and it will load it into something we call e-courts, because we're moving to everything being electronic case jacketing, and it all starts in there. So that's how it all comes together. The judge is able to see that once it's loaded, the prosecutor, PDs, and our court staff, of course, will be able to see it.
There's a lot, but we haven't got a lot of time,
We
so I'm
do,
going to
we
keep
do.
moving
We're
on
just
this.
trying to move. And I really want to get to your questions, because I think it's more probably helpful if you guys have that. So part of it is the communication strategy is the key piece, and some people have asked that question. Getting the right people to the table to start this process is very important. And as we've mentioned a couple of times, our acting director and our chief justice have been on the forefront of getting those partners to the table for us. They've started the discussion, and we have to remind them that this was sometimes we need reminding, and we need to remind our partners that this is not a judiciary policy, procedure change. We didn't decide this. The people of New Jersey decided that they wanted this change. And it's a law change, and now we all have to live by it, and we all have to come together to live by it. So you need to make sure you have those conversations with whoever your partners are, your attorneys, your prosecutors, PDs, and even your county people for facilities and stuff.
This will be the last slide we show. The one other probably thing before we ask for any more questions. We're finding now maybe the biggest problem with communication or getting buy-in, and it's not that big a surprise, is with prosecutors, because this is going to change their world dramatically. And when you had somebody who's been in jail for a month or two, and you look at them and say, well, how about time served, you can go home, probably easier to get that plea than when the person's out and about and doesn't have that pressure and all those other things we're talking about that happen when you're locked up, especially if you're living a marginal lifestyle. So this right now is I guess a key area for us to work on. You guys have any more questions? We got maybe 5 minutes.
I'd rather take your questions than hear about us talking.
Under the new system, does everybody have to see a judge, even those defendants that would have been able to bond out immediately?
That no longer will exist. You won't be able to. So if you're charged on a complaint warrant, which is our, we have complaint summons, which they'll just be, here's your summons, you return to court on this date, see you later, you don't have bail. If they're on a complaint warrant, they have to go into the jail, they have to go through the PTS process, and they have to see the judge before they can be released. And that's what's done within 48 hours.
Are those typically only felony charges?
Yes, indictable cases, indictables, yes.
So in effect, there are no bail for 48 hours.
What happens is if you've got that complaint warrant, everybody charged with that will have to go to the county jail. That's a big change because a lot of folks got charged, got bail, got out before they ever got transported to jail. That's a big change for the jail. They're now going to be doing about 15,000 intakes. It's a big change for municipal police because they're going to be transporting those folks. That's why the decision on whether to put them on the summons or a warrant is big, because if it's a summons, as Shannon just said, they won't have to go through.
Right.
We're waiting still at the moment for the Attorney General to issue guidelines on which to do.
That was my question.
Yep.
Who makes that decision whether it's a warrant or a
Well,
summons? When we changed our law in Pennsylvania to the summons procedure, the police were very adverse to that.
Right.
It took them a long time to come through, but you have guidelines.
Well, our Attorney General is going to be issuing guidelines on what should go on a complaint and summons, and we have a summons or a complaint warrant. We do have some crimes that have to go on a warrant. There's no ifs, ands, or buts. I think we can all figure out the higher level crimes. that do that.
And
But-
when the person's arrested, the police are going to have limited, it looks like they're going to have limited access to our tool to get the preliminary scale that they can use to discuss with the municipal judge or municipal court administrator who makes the decision first on probable cause, but secondly, after that on whether to do the complaint, summons, or the warrant.
For the folks that are on monitoring, do you charge them for the things like drug testing and GPS?
No, that's not in the cards.
Good. We wouldn't either.
Other questions? I know we ran through it, but just to final everything, we have some things that are already in effect. We were able to implement some of the things. Like I talked about the centralized first appearances, we've already started to move to that. We have, I already talked about it. We have some pilots that have started. We've started talking about what they're seeing. The hirings are starting for our new positions. We hope to have them all in place by the fall. And then 1/1/17 is when we do full implementation.
Have you had any pushback from the criminal defense bar looking to get the risk assessments ahead of bond arraignments?
They will have it. Our PDs,
What's the mechanism for them to
well,
get it?
we have the e-courts that I discussed, the electronic jacket. If the public defender's office has agreed to represent everybody at this initial 48-hour hearing, whether you're going to get a private attorney or not at that juncture, just so that there has to be representation at that point. So the public defender has agreed to do that. But if you have private attorney who says, no, I want in on the case, they have a way of we can add them to the system, and then they can view everything right then and there before that hearing.
I mean, generally, they're very much in favor of this, obviously, because their clients are getting out, and things are going to swing more to their side.
And I just wanted to add one more thing. I'm sorry. On detention hearings, we talked a little bit about it, but when the decision to have detention, to ask for detention is done, within 3 days of that decision, there has to be a hearing, and the judge will hear both sides and determine whether or not that person should stay detained or be released. There are some requests. I mean, obviously, the state or the defense can ask for a postponement, but they're very limited. It's 3 days for the state and then 5 days for the defense. So within generally 8 days, you will have a decision on whether or not you're being detained. It's not indefinite. You won't be held for a period of time.
That's when the prosecutor moves for preventive detention.
Right,
Didn't
yeah.
start with that. That is a huge thing as well. Hopefully we've piqued some questions. If you have more questions, like we said, we aren't necessarily the right folks, but we can certainly get you to the folks that are the experts in New Jersey who are doing this and get you some answers to your questions if you have any. I think that's it. Thank you all very much.
Thank you.